Yes, Mr. Knox.
My Lords, 2 points before I resume. The first is the point I was asked this morning about the Articles of Association.
Yes, please.
My Lords, we have been able to dig up Paycheck Directors' Articles of Association. They have the same article. They're not identical because this article, as you were mentioning, my Lord, Article 12b, is now Article 8b.
8b of...
the Paycheck Directors.
Is
articles.
it? Oh,
yes. So it's there, but the articles are not, in other words, not all the articles are the same, because obviously
Yes.
4 have gone.
I think the judge referred to 12b. I don't know quite why he did that, but that was the number he gave. But you say it's 8b.
It's 8b in Paycheck Directors' articles.
Right.
And my Lord, just 1 point. I think your Lordship might have been putting to me that article allowed there to be, as it were, just any one director to sort of, as it were, take over the functions of the company on his own. My Lords, I'm not sure if that was the point that you were putting to me, but if it was, my Lords, what we would suggest that article is doing is simply allowing, where there is just one director,
Yes.
it is allowing there to be just one director of the company. It's not authorising one director to act without the consent of the others.
No, I don't think I was going that far.
My Lords, I was concerned that maybe that was the point, but my Lords, that's not what we would contend for. My Lords, the other point is this. I mentioned that there was, I mentioned in my case that there are 2 lines of authority before 1980 about what is the nature of the duty of a director in relation to unlawful dividends. Is it, so to speak, a strict duty never to pay a dividend at all, an unlawful dividend at all, regardless of fault? Because there was 1 line of authorities, which I refer to in paragraph 86 of my case, which, when you look at the obiter dicta, rather suggest it's a strict liability, if I can put it that way. You just mustn't do it. And my Lords, pre-1980, the rule was you mustn't pay dividends out of capital. You could only pay out of profits. But there wasn't the structured system you've had in place since the 1980s Companies Act. 1 line of authorities would suggest, if you simply looked at the words themselves in the judgments, that it was a strict liability. But those cases didn't, in fact, consider whether fault was necessary or not. There was then another line of cases which said fault is necessary, and they are referred to in paragraph 87 of the case. And probably the judgment which deals with the point at greatest length is the judgment of Mr. Justice Vaughan Williams at first instance, where he, in the late 19th century, he, and I don't want to go to it now, but my Lords, just for your note, he explains why it is he believes it is right to say that there must be some element of negligence. In other words, a director is not liable simply because he procures the payment of an unlawful dividend when there's insufficient, otherwise than from profits. He's liable only if he has not exercised reasonable skill and care in coming to that judgment. And that's the Kingston Cotton Mill case at tab 36, and it's pages 345 to 348. That's the longest discussion, and that's really the only detailed discussion on seasonal point in any of the cases. Now, my Lords, in 1980, the position changes because you have the Companies Act 1980, which was passed pursuant to a directive in 1977, which sets out a new scheme, a detailed scheme for how dividends are to be paid, how you are meant to assess whether to pay a dividend. And essentially, you're meant to assess it against the accounts. And that in turn imports the notion, I don't want to waste time now, but it imports the notion that you have to make a reasonable judgment, especially in relation to interim dividends. You have to make a reasonable judgment as to whether the money is there to do it or not. Now, the consequence of that is that since 1980, and indeed under the 1985 Act, if you don't make a reasonable judgment, you will be making an unlawful dividend. So the question of fault or not, there isn't really, if I can put it this way, it's a slightly arid debate to ask since 1980 whether it's strictly speaking a fault-based liability, because by definition the dividend's unlawful only if you've come to an unreasonable judgment, and therefore you will be in breach of your duty of care anyway in making that payment. My Lords, that's subject to just the 1 point which I don't want to spend time in dealing with, but I do make this point in the case, supposing one was to make the finding that the directors are in an impossible position and the least bad of all alternatives to save everyone is actually to make an unlawful payment of dividends. Supposing we come to that conclusion, this is disastrous if we don't pay, because all the men will go, and it's better to pay a small sum now rather than face far worse consequences in the future. If that is the case, is the director in breach of duty or not? My lords, I would say not, but my lords, that is, we're getting into a territory here. I'd have to show that it was a reasonable, Mr. Holland acted reasonably in any event. My lords, so that particular issue arises only, if I can put it this way, at the tail end of my case. My lords, if I can now go back to the question of remedies, I've taken to the Target Holdings case, which deals with equitable compensation awarded for breach of trust. And I submit, my lords, those are the principles. Even if Mr. Holland is to be assessed, as it were, as if you were in breach of trust, you apply those principles in Target Holdings. I'm going to come to the Bairstow case in a moment. Can I just mention one or two things about Target? There was an analysis of the Target Holdings case by Sir Peter Millett in an article in Law Quarterly Review, I think in 1998, where he had a rather different analysis. He said, putting it shortly, Lord Brown-Wilkinson got it right for the wrong reasons. And you can find that in volume 8, tab 91. And if I can summarise in a sentence or two what Lord Justice Millett said in that article, as he was there. And he said, the right analysis is that the fundamental duty of a trustee is to account for the monies which are under his trust. If he makes an unauthorised investment in breach of the terms of his trust, the beneficiary can come along and say, that's nothing to do with me, you must restore that trust fund. That's the primary right of the beneficiary, because he can simply say, the money, as far as I'm concerned, hasn't left your account. You must treat the money as still in the account. On the other hand, what the beneficiary can do is adopt the transaction and say, oh, I see you've invested it in something you shouldn't have done, but nonetheless, I'm happy with the investment you've made, at which point he loses his right to complain about the investment, and he then, as it were, his rights are then transferred into the investment rather than the cash sum that was used to buy it. That's the standard position. If, in fact, the trustee, if, in fact, the beneficiary rejects the investment, says, I don't like the look of that investment, I want the cash back, the obligation on the trustee is not, so to speak, to restore the very cash itself that was expended in specie. He just has to get some money back into the trust account. He can use his own funds to put into the trust account.
The amount is the same.
And the amount is the same,
from.
yes. Lord Justice Millett explains that you could have got to the target result by that method in any event. It's a slightly complicated reason in the end. But, my lords, what I say is that even on that analysis by Lord Justice Millett, more traditional analysis, what has to be brought into account by a in favour of the trustee is this. If an unauthorised investment is made, let's say £100,000 is misapplied, it's spent on something that shouldn't have been applied, but say, as a result of that, £50,000 comes back into the trust estate before anyone finds out about it, as a result of that investment. Let's say some income comes in of £50,000 from the £100,000 wrongfully spent. Then in my submission, it's clear that the trustee can bring that into account against his liability to account for the full £100,000. He can say to the beneficiary, true it is, I misapplied £100,000, but £50,000 has already come back into the trust estate from that misapplied investment, and I now want to have that given, I'm entitled to a credit for that.
What does that £50,000 represent in your example?
Well, in my example, it could represent either capital or income.
Yes.
Exactly. Yes. There might be questions as to just how, interest and so on, but subject to that, I submit it doesn't matter whether the £50,000 that comes back in is, so to speak, from the sale of the property, and there's a loss of £50,000, or it's just a jolly good investment as it happens, and it's yielded an income of £50,000 in the relevant year. In either event, the trustee can say, bring that into account for my credit. My lords, there are two old cases which suggest that is the right analysis. I don't want to go to them now because they take a bit of time to go to. They're not very long. One is called Fletcher and Green, at volume 2, tab 13. Another is Knott and Cotty, volume 3, tab 19. They're both quite short reports, but in both of them, that there was a profit, as well, there was a profit element in the wrongfully made investment. The beneficiary said to the trustee, no, I'm entitled to that profit element. And the court said, no, the trustee is entitled to that profit element as a credit against his liability to account for the misapplied funds. And that was the result effectively in both those cases. My lords, there's also the case of Bartlett and Barclays Bank, where the bank embarked upon, as were, an unauthorised sequence of investments. One of them lost massively, but I think the decision of Mr. Justice Brightman, rather surprisingly, another one did rather well. Beneficiaries said, well, we can keep the one, you obviously must pay, must restore, you're allowed to compensate us for the wrongful investment in the full amount, and you cannot, as it were, have a credit for your good luck on the other investment. And Mr. Justice Brightman said, well, the two were really all part of the same sequence of investments, albeit different investments, and the gain on the one could be offset against the loss on the other by the trustee. And the reference is 538C to E. And Mr. Justice Brightman does note that there aren't very many cases on the point, and he says they're, I think, centenarian cases, but they're pretty old. And it's quite difficult to find cases which consider this point in much detail.
Did you give the reference to that case? Is it volume 1?
Volume 1, file 6.
Thank you.
And these are all equitable compensation cases.
Well, it claims against trustees for breach of trust and therefore equitable compensation.
But not breach of fiduciary duty.
Well, they would. I think breach of trust. Yes, it'd be acting misapplied funds in breach of trust. Yes, rather than breach of fiduciary duty. Yes. But, my lords, I would submit, even in the case of breach of fiduciary duty, if what the beneficiary elects to go for is equitable compensation as opposed to an account of profits, because he's got that election, then the equitable compensation is still assessed in the same way, i.e. by reference to the net loss. My lords, that leads to Bairstow,
Yes.
which is the decision on which the Court of Appeal relied, and that, my lords, is in tab, I think. Sorry, file.
Well, it's tab 3, I think.
File
You're going to the Court of Appeal, are you?
Yes, the Court of Appeal decision, my lord. I just want to go to that. My lord,
Yes.
file 1, tab 3. My lord, I don't want to go to the facts in detail. Can I summarise? The facts are quite complicated, but for present purposes, what matters is this. If I can just summarise the bones of the problem. The directors of Queen's Moat House in 1990 paid 4 dividends against the 1990 accounts when there were insufficient profits to justify those dividends. There were other dividends too, but there were 4 in particular. And in 1991, they paid out, against the 1991 accounts, they paid out 5 unlawful dividends. So that was the amount of dividends paid out. Now, the 1991 dividends were paid out against inflated accounts, deliberately inflated accounts to mislead the market. But that wasn't the case in relation to the 1990 accounts. But in both instances, the payments were wrongfully made. And my lords, the directors raised a number of points, but one of the points they sought to run in relation to both sets of dividends was this. They said, well, look, true it is, the parent company which declared these dividends and paid them all out didn't have sufficient monies in their account, or hadn't made sufficient profits to justify the payment out of those dividends. We accept that. But, they said too, the fact is there was money in the subsidiaries which we could have drawn up from the subsidiaries, which would have justified the payment of, which would have justified us making those payments. So they were saying sort of, well, although we weren't allowed to do it, and although it was wrongful, nonetheless we could have arranged things in such a way that we could have done it anyway. And the next step of their argument was, and it follows from that we shouldn't be held liable for any loss in relation to the dividend, because the companies didn't, as we were on a proper analysis, suffer any loss as a result of our wrongdoing, because we could have done this anyway had we only drawn the money up from the subsidiaries. It was a pretty contorted argument on causation, and it was dealt with in the Court of Appeal in my Lord Walker's judgment. And I think if I can ask you to take the first passage I want to look at is paragraph 37. Which sets out the principle in Flitcroft's case. And you can see, I'm just using this really as a summary of the general rule which is set out in Flitcroft's case, 37 to 39. This is the basic approach in the case of the payments of unlawful dividends. This is in context of a slightly different argument, but this is the basic approach. I accept this is, as it were, the starting point. And in particular, it's the quote of paragraph 39. Directors are quasi-trustees. They improperly pay away assets, they're liable to replace them. My Lord, I accept that would be the normal starting point. And my Lord, that, if I can put it this way, is because 99.9% of the time, of course, the payment out of the unlawful dividend will not produce anything in return. It's just money out of the window. My Lords, I would also add this. It must be the case that if unlawful dividends are paid out, thus reducing the capital of the company available to enter into, let's say, a very profitable contract, and therefore the company sustains the loss not only of the unlawful dividend, plus and also a loss as a result of the loss of the profitable contract. It's difficult to see why the company couldn't sue the directors for both. The reason I make that point is because it shows that the real duty here is to compensate for the loss caused. And if it goes that way against the directors, namely they are liable for more than just the unlawfully paid dividend, so too it must follow, I say, that if the loss eventually causes less, they must be entitled to the credit as well. It would be very odd if it didn't work both ways. My Lords, one then moves to paragraph 53. The passage begins at 49, my Lords. And my Lord Walker says, Mr. Pearl boldly attacked the proposition that the delinquent company director should be equated with trustees for the purpose of measuring their liability to make good losses caused by breaches of fiduciary duty. He submitted the early authorities must be read in the light of Target. Paragraph 50, there is ample authority establishing that although company directors are not strictly speaking trustees, they are in a closely analogous position because of the fiduciary duties which they owe to the company. And then there's a reference to Lord Porter's dictum. And then further cases are cited in paragraph 51. And then paragraph 52 describes the facts of Target Holdings. And I just want to emphasise the passage right at the end of paragraph 52. The claimant, as a possible shortcut to having to prove fraud at trial, sought summary judgment on the basis of the unauthorised payment, despite the solicitors having obtained the security, which subsequently proved hopeless and inadequate. That is the explanation of the references in the speech of Lord Brown-Wilkinson to stopping the clock. My Lord, that's a phrase I'll come back to in a moment. And then the result reached in Target has been welcome, but the route debated, and then there's a reference to Lord Millet's article. No need to go too far into that debate, because whereas the trust in Target Holdings was an aspect of a wider commercial transaction involving agency, the fiduciary obligations undertaken in this case by the former directors involved heavy and continuing responsibility for the stewardship of the assets. Not strictly speaking trustees, as title of the asset was invested in them, but they had trustee-like responsibilities because they had power and the duty to manage the company's business in the interest of its members. It may be a more satisfactory dividing line is not that between traditional trust and commercial trust, but between a breach of fiduciary duty in the wrongful disbursement of funds, of which the fiduciary has this sort of trustee-like stewardship, and a breach of fiduciary duty of a different character. These points were not fully explored in the course of argument. It wouldn't be right to express a definite view on them, not necessary to determination of appeal. Sufficient, in my view, to observe that this is a wholly different case from target holdings, in which, so far as concerned the application for summary judgment, the solicitors were shown to have done no more than to have acted imprudently in dispersing their clients' funds before they obtained their client's security. In this case, the former directors are liable for deliberately, and at least in relation to 1991 accounts, dishonestly paying unlawful dividends out of the company funds in their stewardship. Those unlawful payments have never been reimbursed. And then importantly, my lord, this phrase, Queen Merritt's case does not depend on any artificial exercise in stopping the clock. The judge rejected the submission as no loss because the lawful dividends could and would have been paid, and so on. But, my lords...
Well, it's the final sentence, isn't it?
But even in the absence of such finding, the submission was, in my view, bound to fail. Yes, my lord. This was... on the facts of this case, my lords, on the Bairstow case, I submit it was a hopeless submission in any event.
I see. So,
That's what because the causation point is so contorted.
Sorry?
The causation point that was being argued for by the directors in the Queen's Merritt case was so contorted.
Right.
And they weren't saying what we're saying, that some benefits came back in for the unlawful payment. They weren't saying that. They were sort of trying to say, well, I could have done all this anyway, had I only done so, by pulling money up from the subsidiaries. Well, my lords, it's difficult to see how that could give rise to any sensible causation argument in any event. And so, I do respectfully submit that, although I don't attack the decision in Bairstow, because I submit on the facts it would be right. This is a correct application of the law on the facts being contended for. I do respectfully submit that we are in a totally different position here, because stopping the clock is exactly what the revenues claim depends upon. What it says is this. Week 1, say £200,000 worth of dividends is paid out. Let's stop the clock there. By the end of week 1, let's say £190,000 has come back in. Ignore that altogether. Week 2, another £200,000 is paid out. Right? Let's stop the clock at that point. Another £190,000 comes in at the end of week 2. Well, we'll forget all about that. And then you start off with week 3, and so on and so on and so on. So it's a constant stopping of the clock at the end of each week.
so you say that final sentence is not a rejection of the compensatory approach?
No, certainly. My lords, I say no. And my lords, I say if it is a rejection of the compensatory approach, I submit it is inconsistent with target holdings, and the reasoning in target holdings should be preferred. But my lords, I submit on a proper view the point that's being made is applicable to the facts of that case, and certainly not applicable to the facts of the case we have here. And my lords, I submit it would be inconsistent with the breach of trust cases which I've mentioned. That's to say that the older cases, Fletcher and Knott, and indeed with Bartlett, which are all proper breach of trust cases, if I can put it that way. Not just mere commercial transactions. Now, I think it's right to say would involve sort of family trusts and things, trustees paying away monies which they shouldn't have done in the usual trustee context rather than the commercial context. So, my lords, what I submit in relation to Bairstow is that it does not authority against the argument for which I contend. And indeed, I would say this, there is no case anywhere which says that the misfeasant or wrongdoing director is liable to pay an amount in compensation greater than the net amount of the loss caused by his wrongdoing. And one can go through McGregor on damages, and you won't see any such proposition. And my lords, I haven't been able to see anything in any other textbook on equity or trust which suggests that the compensation is ever a sum bigger than the net loss sustained at the end of the day.
Yes.
So, and my lords, Clive says that I understand that, in fact, in Bairstow, the directors were given permission to appeal on this point. I understand that from one of the counsel involved. So, it's it's a real, if I can put it this way, although I haven't, it's a real, if I can put it this way, Supreme Court point in any event. And it cannot be said that it's clear from the Court of Appeal authorities what the answer is. But I submit, you have my submissions, target must be right analysis. My Lords, if I'm right on this, on the compensation point, I say this, assume against me I lose on the corporate director issue. Assume I lose on that. I say that the most the court should do is allow the appeal, but only on terms that there is to be an assessment of the loss, as set out in my case, namely, on the basis set out in my case, namely taking into account all benefits and savings received as a result of the unlawful payment of dividends. My Lords, that would have a very important impact on the case as a whole, and indeed on whether any relief should be given under Section 212, because, my Lords, if the loss was nil, there would be no order to be made under Section 212. My authority for that is a case called In Re Canadian Life, which is at file 3, tab 26, where the point was made that if there is no loss, there may have been a wrongdoing by the director. I should say I don't think it's an unlawful dividend case. But the point is made, if there's no loss, then there's no grounds for an order to be made under Section 212. It's not, so to speak, a declaratory section. It's just a section.
Yes, it's hard to see what order one could properly make if there's no
Well, indeed.
loss.
But my Lord,
You could examine into the contact, but it would be a fruitless exercise.
sorry? Yes.
Yes.
My Lords, I can deal very briefly, I hope, with the remaining three issues. The fourth issue is the Section 212 discretion. I'm conscious of the time, my Lord, so I hope I can deal with it briefly. I'm not going to say much more than is set out in my case, so I'll deal with it in summary form, if I may. My Lords, the starting point is this. The judge had some sympathy.
Which paragraph of your case do we look at?
It's paragraphs 106 to 115.
Thank you.
My Lords, one point which I don't mention in the case, which I said at the starting point, and I should have mentioned in my case, is this. The judge had some sympathy for the proposition which we were running, namely that the court should be taking into account a broader picture than that intended for by the revenue, and in particular, the point that, well, this was all a bit of a windfall for the revenue. It emanated from a totally unnecessary mistake in the structure. And what is more, my Lord, this was always the point that I was making, what is more, if we'd stopped trading, the revenue would never have got higher rate corporation tax from the men's labour for an equivalent entity to which they moved. And that was always the point that was being made. In other words, if you looked at the matter between the revenue and Mr. Holland and asked, well, was the revenue itself worse off as a result of the course he took? The revenue is the only creditor. Was the revenue worse off? The answer is no. Paradoxically, it's rather better off. The only sense in which it's worse off is that as it accrues a notional debt due to it, which is never going to be paid. In that sense, it's worse off. But in practical terms, it is actually better off. Because you save the costs which are going to be incurred by closing the business immediately, which eat into the saved-up reserves for lower rate corporation tax. My Lords, that was the point. And the judge expressed some sympathy for the point in paragraph 230 of his judgment, but said, I don't think my discretion is that wide. Page 114.
Yes.
So it's there. I accept it's not. I don't say it. My Lord, he says, was saying in terms, I would have accepted it, but on the other hand, he's certainly saying I wouldn't have thrown it out. And my Lord, this, of course, is on a matter of discretion, and there is no doubt that Section 212 does give some discretion. So he was saying it's just not as wide as that. And that's the basis on which he's not taking this point into account. Now, my Lord, just as a matter of law, what I say is this. Looking at the words of Section 212, I make two basic points about it. First, the discretion is on the face of the statute, unfettered.
And you find that in the word may, do you?
May,
It's as simple
yes.
as that.
And you've got the A and the B, may, and the A talks about restoring part. And so A seems to be proceeding on the premise that although A seems to be talking about the case of ordering a trustee, the director, to pay back money he has himself received, hence repay, restore.
Yes,
B seems to be talking about the case where he's being ordered to pay compensation.
yes.
But in both cases, there seems you've got may, and in both cases there seems to be a general power in the court to reduce from the amount that would otherwise be awarded to a lower amount. Now, what I say is this: first of all, if you can reduce, let us say, from £1,000 to £1, it seems almost absurd to say you can't reduce from £1 to £0. So I say, on the proper construction, this can be reduced to 0. In principle. Secondly, my lords, I submit the discretion is broad and it gives the court a power to do what is just in all the circumstances, especially in relation to B, compensation as is just. It doesn't say the compensation which would otherwise fall to be awarded. And my lords, it's common ground that the courts have, in many cases, reduced the award below what it would otherwise have been. There's no doubt about that. My lords, what I say is this: as long as there are reasons, good reasons, on the particular facts of the case for reducing an award, it can be reduced as the court sees fit. This section is not depriving the court of that jurisdiction. My lords, as far as a matter of as far as the first point is concerned, can an order of nil be made? There's one decision I've been able to find. The first is this decision of Mr. Justice Wright called Sunlight, which is at 554, where he made an award, effectively made an award of nil, and therefore said, I'm not going to make an award. It was on different facts, I should say, but he said, I won't make an award in this case. He exercised his discretion to come to nil. My lords, on other cases, they've been referred to in the courts below, especially in the trial judge's judgment, especially in re locutor, my lords, is a case where Mr. Justice Etherton, as he then was, made quite a substantial reduction in the award that was to be paid by the directors.
So locutor wasn't to nil, but it was a...
It wasn't to nil, but it was certainly a reduction from that which, as it were, in an action by the liquidator could have got. And my lords, putting it in a nutshell, I say simply this: where the creditor is exercising the right, not the liquidator, where the creditor is, so to speak, coming in, and the liquidator has decided, as in this case, not to sue. Because, my lords, the liquidators there's no question of the administration or liquidators suing in this case. Where the creditor sues, and you therefore have an issue between the creditor and the alleged misfeasant director, in my submission, the court is entitled to take into account the relative position as between creditor and director, for the reasons I set out in paragraph 113 of the case. My lords, I don't want to repeat them now, but it's set out in paragraph 113 the 2 points which I say the court could properly have taken into account. The first point being, in real life, did the revenue actually lose anything as a result of Mr. Holland's conduct? We say no. My lords, it's never been explained how it could have done. Secondly, we say, the judge accepted that the revenue had behaved badly, he accepted that, and that had it not done so, these problems might not have arisen. My lords, I submit not an irrelevant consideration when you are dealing with a man who, on any footing, found himself in a very difficult position, who behaved honestly at all times. That's the judge's reasoning.
But even if the application is made by a creditor, the money goes to the company.
It does indeed. In this case, my lords, of course, it's going to go straight back out to the creditor. I accept that, my lords. But you could take all that into account. I fully accept, my lords, that you'd have to take into account where's the money going to go eventually.
So that if in a perhaps different case, well, it would be a different case, a particular creditor uses the procedures of Section 212 and says, in effect, it ought to be £1 million, and because that's what I'm owed. The £1 million goes into the company, there then may be lots of other creditors, with the result that the creditor who's asking for his £1 million might only end up with a dividend.
Yes, he might. Yes.
And all that would be taken into account.
All that would be taken into account. And clearly, if that was the case, you would say, well, there's no reason really to reduce the award because of the conduct of the creditor, because the money will go to the pot, and the pot will then get distributed. But if, in fact, the reality is the money will go into the pot, but only for 2 seconds before all of it goes out to the creditor.
Well, that's overstated a bit, because there are 42 separate liquidations and 42 lots of liquidators' fees to come out. So that's going to be more than trivial, I think, isn't it?
My lords, yes. My lords, well, they would have come out in any event, my lord, from the reserves that were saved up for lowering corporation tax. But my lord, your lordship is right, yes. But, my lords, you have my point. I say that would be a factor for the court to go. I fully accept your lordship's point. It would have to be subject to, as well, if you attributed those costs to the money coming in as opposed to the money there already, yes. So, my lords, that's what I say in relation to section 212. My lords, finally, one fallback point. Supposing I'm wrong on my compensation argument, supposing, in fact, there's a duty to restore the full amount, therefore prima facie liability of 1.3 million in law, I submit, well, there's no reason why, as a matter of discretion, the court could not, as the majority of the Court of Appeal did, reduce it to such loss as was eventually sustained by the companies. The reason I say that is, on what basis can it be said to be just that, or rather, it is just that an amount is that the wrongdoer is asked to pay only that can compensate the loss which his conduct has caused, and there's no reason has been identified with respect as to why that wouldn't be just.
But would it be just to, supposing the measure of damages or the measure of recovery is the loss, you're inviting the court to reduce it further, right, to less than the loss?
No. Well, I am, yes. I mean, my primary argument is, I say you look at the, as well, respective positions between the revenue and Mr. Holland himself. That's in other words, you get to nil anyway. If I'm wrong on that, and I'm also wrong on my compensation argument, I say you bring in the compensation argument under section 212 in any event. And so the right order under section 212 would be simply in order that we reimburse such loss, if any, as has been sustained, bringing into account all benefits, including savings made. My lords, in the Court of Appeal...
But if the measure of loss, if you win on the earlier point, are you asking for a further reduction under section 212?
Yes. I mean, my lords, yes, I'd be saying this. Theoretically, because I'd be saying, in any event, the claim should be dismissed because the revenue itself didn't sustain the loss as a result of, for the reasons I've mentioned. So it is a further argument. It comes in two different ways. First, as a standalone argument. Second, as a backup argument to my compensation argument. My lords, that leaves the 5 days grace point. Well, my lords, I simply say the Court of Appeal got it right. On any,
well,
the question is...
There's a majority view in the Court of Appeal.
Yes, the majority got it right.
Yes.
My lords, and same as the judge,
yes.
My lords, I submit that the reason it can be justified is this. The question is, did Mr. Holland act reasonably? Doesn't matter what he was thinking. Did he act, as it were, look at his actions in that 5-day period. Would one say that not doing anything for those 5 days was necessary, in the aftermath of what happened, was the act of an unreasonable man? I say, well, you must allow him some time to think. It's not unreasonable that in that period, you couldn't castigate his conduct after 5 days as unreasonable. And it's understandable that you wouldn't want to make such a serious decision within 5 days. If he'd stopped immediately, before he'd had at least some time to think about it, he'd have been exposed to a claim, well, you did an absurd thing. You stopped paying out the dividends straight away, without even getting expert advice, after you've been told by your lawyers that, well, it was a balancing act. So I submitted the actions he took over those 5 days, or what he did, was not unreasonable. Time to take stock. That's a short point, my lords. And then finally, my lords, is section 727 point. My lords, I've set it out in my submission.
Yes.
And my lords, I don't propose to repeat them all again.
And that's your case, paragraph 117 onwards.
Yes. Yes.
Yes, thank you. Thank you very much, Mr. Knox. Mr. Casey?
My Lord.
Thank you. Yes, Mr. Green.
My Lords, I'd like to briefly return to de facto, if I may. Corporate Director. My learned friend's argument, one of his main arguments, is that it would be inconsistent with the scheme of the 1985 Act, which allows a sole corporate director to act. So if that is the case, one would have expected to see, so the argument goes, it expressly stated somewhere in the 1985 Act that there will ultimately be a human being liable because of the de facto doctrine, or in some way, some sort of recognition of that. However, we would say in answer to that, that both Bulawayo and Salomon say nothing about directors' liabilities. Bulawayo, as your lordships will recall, was the case that established that there can be a corporate director, that was not contrary to the intent of the Companies Acts. But there was no contemplation or recognition of the concept of de facto directorship at the time Bulawayo was decided, certainly not in this context. Salomon, as I've already submitted to your lordships, is only about shareholders' liabilities, not about directors' liabilities.
Well, that's perfectly true, but if one looks at it in a slightly non-legal way, in both Salomon's case and the case in front of us today, could it not be said, well, you're going through what we call the corporate veil, in the one case as far as shareholders are concerned, in another case as far as directors are concerned. And the rationale for doing that is just about exactly the same in both cases. If you look at the argument of the unsuccessful respondent in Salomon, it is it not, very similar to some of the arguments that you're addressing to us.
But, my Lord, we don't seek to go through the corporate veil to get Mr. Holland as a director of the corporate director. We do not seek to make Mr. Holland liable because he's a director of Paycheck Directors. We seek to make him liable because of what he was doing in the composite companies. And this, with respect, was the point that was recognised in the Pakistan National Shipping case. It's nothing to do with de facto directorship, I accept that, but the point that was made there very clearly by Lord Roger is that Mr. Mehra was not being sought to be made liable because he is a director of Oak Prime, but because he committed those frauds. In exactly the same way, we don't seek to make Mr. Holland liable because he's a director of Paycheck Directors. It's nothing to do with the fact that Paycheck Directors, the de jure director of the composite companies, is a company. It's because of what Mr. Holland was actually doing. And we submit that the question, it's not really a question of company law. It is simply a question of agency and principle. Mr. Holland was the agent of Paycheck Directors because he was a director of Paycheck Directors. Question is, does that capacity prevent him being found to be a de facto director of the composite companies? We say no, capacity cannot be relevant. And my Lord, that can be tested by this scenario. If Mr. Holland was not actually a director of Paycheck Directors, but he was merely an employee of Paycheck Directors, he did exactly the same as he was doing in relation to the composite companies. Is the respondent's case that he would still be he would not be a de facto director in that situation? Surely.
But I don't follow that. I mean, to just explain that more fully, would you? Because he wouldn't then be doing what he in fact did, because what he in fact did, he did as a director of Paycheck Directors.
Well, presumably what the other side would say, he was only, whatever he was doing in the composite companies, he was doing as an employee, as a fully authorised employee of Paycheck Directors. He wasn't doing it in any capacity or he wasn't assuming any role of directorship in the composite companies. He has a lawful appointment, he's been made an employee.
But what would he actually be doing on your scenario?
Exactly the same as he was doing in this case, pressing the buttons on the computer and allowing the composite companies to continue to pay unlawful dividends.
You mean the mechanical exercise of the actual payment?
Or
No,
making
the ultimate
decision.
decision-making. The decision-making, he is the person who is making the decisions, and he can have authority from the Paycheck Directors Board, assuming he himself is not a de jure director of that, say Mrs. Holland, can give him authority to act in relation to the composite companies. He does so. On their argument, that gets him off the hook, because he's acting with lawful authority in a particular capacity. We say it doesn't matter. It doesn't matter whether he was an employee, whether he was a director, or whether he was a consultant appointed pursuant to a lawful contract. All of those capacities are irrelevant. You just simply look at what he is doing. And the fact that he was a director of Paycheck Directors is neither here nor there. That was the actual role that he was appointed to by Paycheck Directors, but he could be doing exactly the same things with some sort of other lawful appointment. And if it doesn't matter, therefore...
But he couldn't have been paying the directors or paying the dividend, or procuring the payment of the dividend, except qua director of Paycheck Directors, could he?
Well, it was actually Paycheck Directors that is paying the dividend. They would still produce minutes, presumably not in exactly the same form, because they would need to have who is the actual de jure director of Paycheck Directors on the minutes. Your Lordship will recall it said M. Holland, Paycheck Directors. It would have to be somebody else on this scenario. But assume that could be done. There would be no possibility on the respondent's argument of him being found to be a de facto director, and yet in our submission he's doing exactly
This assumes
the same
what?
thing.
That he instructs or causes to be instructed, whoever is the de jure director of Paycheck Directors, to do what he in fact did, as we see on the bit of paper. Is that right?
Yes. But he is the effective decision maker.
Because he's the decision maker throughout the whole
Yes.
quote, group, unquote.
And what it demonstrates is that the fact that Paycheck Directors is itself a company is irrelevant. The whole issue comes down to capacity, and whether somebody in the position of Mr. Holland can say, I am only acting on behalf of another.
Your argument produces the result, doesn't it, that on your case, Mr. Holland had two hats, and in making the personal decision to pay dividends, he was doing that firstly as the de jure director of the corporate director, and secondly, exactly the same actions, the de facto director of the company.
Well, we say he certainly has the de jure director of Paycheck Directors hat on, but he also has his own personal hat on.
Yeah,
He's not a de facto, he's only a de facto director because he is acting also personally in the matter.
But
and those personal actions...
Yes, I thought all I was saying
become-
is he wakes up in the morning, decides that the companies will pay a dividend, and puts that into effect. And he does so, firstly, well, it doesn't matter which order, firstly as the de jure director of the corporate director, and secondly as the de facto director of the company concerned. So that's what I meant by your case. I'm not saying it destroys it, but entails that he does exactly the same thing in two capacities.
Well, the same could be said for Mr. Mehra in the Pakistan National Shipping case.
Yeah, I'm not
he
saying
was committing those frauds with two different hats on.
Yes, I was only inquiring to see whether you accept that is the position.
Well, we necessarily say that what he was doing in the composite companies, he was doing in his own personal capacity, as well as perhaps a director of paycheck directors.
But I thought you were accepting that there was a precise match between what he was doing in the one role and the other. There's a precise overlap, a precise match. You put the two on top of each other and there isn't any gap between them. And that raises a question, what more is there if you take the de jure position? What is more here? If you're applying the test that you have to look for something more than simply what the de jure director would do or could do.
Well, what we submit that the more that's referred to in the Hydrodan case is simply a reference to the quality of the acts. So if the individual director or the individual person that is controlling events in the composite company is effectively doing everything, that is the more. If your lordships will recall what the non-executive directors in Eagle Trust were doing absolutely nothing except attending a board meeting and were sought to be made collectively responsible. More requires them to actually act in relation to the composite companies.
So if he's the effective decision maker, you say, for everything,
Yes.
that's the more bit.
That's the more. And you, in looking at that issue, you ignore where he says, but I'm only doing it with my corporate director hat on.
You say it's because of his personal control of the whole shooting match, including in particular the composite companies.
Exactly so.
And you say he's the decision maker and the one who gives effect to that decision with his wife's secretarial assistance.
Yes. And my Lord Walker also asked my learned friend about whether there were board meetings of paycheck directors itself, and certainly there's been never been any suggestion of any minutes of paycheck directors being produced. That simply didn't happen. So when Mr. Holland is supposedly appearing at board meetings of the composite companies, he is doing so with some sort of authority from paycheck directors, but not, so it seems, any sort of board resolution or anything like that.
Well, except so far as the documents generated by the computer are or purport to be board resolutions. Is that
Of
right?
the composite companies.
Of the,
They are board resolutions of the composite companies, not of paycheck directors.
yes. Yes, of course they are.
Yes.
Because
They are
the companies that are declaring the
Yes.
dividends.
They'd have to be of any relevance, yes.
Quite. But my learned friends sought to suggest, well, they were sitting in the same room when it was done, so maybe a paycheck directors board meeting took place as well at the same time. My Lord, that's a nonsense. It's clear what was happening. Mr. Holland was controlling everything. He was attending all the meetings with solicitors, with counsel. It was his decision to make. And it would have been his decision to turn off the computer and to stop paying unlawful dividends, and he decided not to. And the whole point of the Pakistan National Shipping case says that what we submit is he should not be able to use his position as director of paycheck directors as some sort of shield protecting him from a liability that ought properly to be imposed upon him. My Lords, the rather absurd suggestion from the...
So are there any, is there a sort of computer printout of any meeting of the director, paycheck director?
Not that we've seen.
They're all minutes of the composite companies, are they?
Because the composite companies are paying the dividends. It's their money, composite companies' money. They pay the dividends. And they're authorised by Mr. Holland with his paycheck director's hat on. So the minutes say.
And also with the corporate director. Both Mr. Holland and the corporate director authorise the payment of dividends.
Well,
So
yes.
if it had so happened...
We would say that.
Yes, but if it had so happened that the corporate director had got plenty of money and Mr. Holland had no money at all, you would have gone for the corporate director. I mean, you're not saying you couldn't go to the corporate director, are you?
No, not at all. And the suggestion is that we are saying these are not acts of paycheck directors. They are acts. They appear to be from the paperwork, and obviously one would want to get the paperwork completely in order and ensure that it did appear to be paycheck directors that was taking all these decisions. So certainly it doesn't get paycheck directors off the hook.
No.
And
What do you say about Mr. Knox's point that, as a matter of principle, in order to be a de facto director, you have to assume the role of a director of the relevant company? You accept that, do you?
I accept that that is that should be treated as the effect of your actions. If by what you're doing, you are placing yourself in a position where you are effectively acting as a director, then as the test for de facto directorship, that must be right. What I do not accept about it is that there has to be some sort of willing assumption of the role of director. That would be to undermine the whole concept of de facto directorship.
Well, I don't think Mr. Knox really suggested that was a necessary ingredient, did he?
Well, I think as I understood it, what he was suggesting is that if, as Mr. Holland says he is only acting as a director of paycheck directors, he is not thereby intending to assume any role in the composite companies, and he is not therefore assuming any duties to the composite companies.
I must say, I find it very puzzling and worrying if this case is going to turn on the meaning of the very ambiguous word assume, which for some seems to have heavy connotations of putting on some sort of cloak or something. In fact, the earliest reference I can find is actually in Sir Nicholas Brown Wilkinson, back in Lowline, which we haven't actually looked at yet. And he said that he thought that Parliament's plain intention was to have regard to the conduct of a person acting as a director, whether validly appointed, invalidly appointed, or just assuming to act as director, without any appointment at all. So there, the Vice-Chancellor seems to be treating assuming as a word of almost neutral content, but in some of the later cases, it seems to be given a more pointed meaning. It's quite puzzling.
Well, I agree with your lordship that it's not. I don't think there's any magic in the use of the word assume. What is being said is, are you doing enough in the companies, in the relevant companies, to at a high enough level, at a directorial level, such that you should be treated as a director, and you should be subject to all the duties of a director. I think Millennium Friend's submission led to his rather extraordinary submission that what we are seeking to do is retrospectively impose de facto directorship on Mr. Holland by reference to wrongful acts. That is not right at all. We say that Mr. Holland was a de facto director right from the word go. Because of the way he structured and set up the companies, he would inevitably, from the first time that the composite companies actually did anything, would be a de facto director. It so happened that at the end of the story, he caused those composite companies to pay unlawful dividends. But long before then, he had become a director, a de facto director, and subject to all the duties that flow from that.
And that's because, as a matter of fact, you say, is this right, he acted as a director, or doing directorial things. And if that's what's meant by assumed, namely the fact of acting, then that's...
He was the person, as is accepted, he was the human being that had complete control of the composite companies. He was the only effective decision maker. He was the person at the top of the tree. And
of course, it might be said that's very similar to what was said in Salomon and Salomon.
Well, except that I think you're saying your target is the composite companies rather than the director companies.
Yes.
Because I mean, he has his role as a director de jure of Directors Limited, the director company, but it's what he's doing in relation to the composite companies. You're saying that's the key, and it doesn't really matter what his de jure role is. You say.
Well, exactly. We say ignore the fact that he's a de jure director of the composite companies. Just look at what he was actually doing.
Although, of course, the only way he could obtain the payment of the dividends was through his role as a director of the corporate director.
Well, as a matter of formality, I would accept that he had to. It was necessary to tick all the boxes and make sure that it was all done in the name of paycheck directors. I dare say, if they didn't have these, if they didn't have these minutes and they were just paying the dividends in some other way, they would still have been paid. I mean, what difference does the computer-generated board minutes? What sensible difference should those board minutes actually make to the analysis of the situation? In our submission, nothing at all. They're just pieces of paper that have no effect whatsoever. And if the effect is, as my own friends suggest, this is an easy way around the disqualification regime and all other methods of public protection. In fact, the position can be tested by going a stage further. What if Mr. Holland had caused the composite companies to act fraudulently? Would that make him a de facto director? Presumably, if when the structure was set up, it wasn't a sham, one wouldn't be able to get home on that ground, unravelling the structure. And if he is not there may be some liability for procuring a fraud, but that wouldn't help in terms of disqualification and other remedies, because they are dependent on showing that he's a de facto director. But their submissions necessarily lead to that conclusion.
Yes, the difficulty with fraud, though, or dishonesty, is that that unwinds just about any company structure you care to name. And the cases have always made clear that that opens everything up. So, but speaking for myself, I don't really get a lot of assistance out of examples where people have acted fraudulently or dishonestly.
But, my lord, it wouldn't, even if all the structures could be dismantled, that wouldn't mean Mr. Holland was a de facto director, and therefore he would not be subject to disqualification, for instance, because one has to...
No, but we then go into all sorts of other considerations as to whether he was in fact the alter ego of the company and whether he actually took part in the fraud itself and so on. It may just be me, but because there are so... The circumstances are so different in cases of fraud or dishonesty. I can only repeat, I don't find examples based on people being fraudulent or dishonest of any particular assistance. But that may just be me.
I'm sure not, my lord, but your lordship has probably got in mind the Pakistan national shipping case. It was
Among
a case of
others,
fraud.
yes, yeah.
But why that helps is that because it indicates where the line is to be drawn. When is capacity relevant? When is it not relevant? When you're in the contractual context, capacity is relevant. If an agent contracts on behalf of his principal, the agent is not normally liable, or can make it expressly clear to the other party that he is not taking on any personal liability, he's only contracting on behalf of the principal. That's one side of the line. Capacity is relevant under the normal agency and principal rules. Fraud is on the other side of the line, as we see from Pakistan national shipping. Query whether directors' duties, fiduciary duties, what side of the line are they on? And in our submission, the most sensible classification is as between voluntarily assumed duties and duties imposed by law. Contract is on the one side, fraud is on the other, a duty imposed by law. We say directors' duties are imposed by law. Therefore, capacity is not a relevant consideration. My Lords, I just wanted to refer very quickly there was a suggestion that the white paper, or when corporate directors were being looked at for the purposes of the 2006 Act, that if there was a concern that people were avoiding liability as a de facto director by the use of corporate directors, that one would have thought there would have been something said about it. In fact, if your Lordships were to look in paragraph 38 of the case, the relevant white paper is in the authorities bundle at volume 8, but the quote is set out in our case in paragraph 38. And it says a corporate director can act only through one or more individuals who represent it or otherwise act on its behalf. The duties of directors need to apply to such individuals. They need to know they apply. If the directors are not individuals, it can be difficult, both for the general public and for regulators, to determine who is actually controlling the company. Now, my Lords, if there was... why is it relevant to determine who is actually controlling the company? What they are clearly referring to is the individuals behind any corporate director, and the concern was finding out who those individuals actually are. Why do you need to find out who they are in order to hold them accountable? So in our submission, there is an inbuilt assumption, which was then ultimately behind the legislation, that those individuals could be ultimately held responsible. The concern was identifying who they are.
Well, is that right? The next sentence is, moreover, it can be difficult to apply sanctions against corporate directors. Could well be read, and I personally would read it as seeing that this is why there is a good argument for prohibiting them altogether, because it's difficult to get behind them.
Well, it's difficult to determine who is actually doing the controlling, but there's no indication in there of any recognition that a corporate director can be used in the way it is sought to be used in this case, in order to protect the individual behind it from potential liability and sanctions. But the reason why, I've made plenty of submissions about how there can be no policy discerned from the Companies Act, quite the reverse, that directors are able to limit their liabilities in any way. But the policy was not actually carried through because they appreciated, as appears from paragraph 39, that there are entirely legitimate reasons for the use of corporate directors. And in our submission, one such entirely legitimate reason cannot possibly have been to avoid liabilities or to limit liabilities.
The example given of abuse on the following page is fraud, though, isn't it?
Yes.
And I suppose the problem would be equally so in the case of fraud. It may be difficult to pin down exactly who it is, and you can't disqualify, if the director is a corporate director, the fraud of an individual wouldn't lead to the disqualification of the corporate director, would it? I don't know.
It could do, but
it's more difficult to achieve.
It wouldn't normally do that. But certainly, the concern seemed to have been as to the lack of transparency and the abuse to which corporate directors can be put. And in our submission, there was no concern that corporate directors can be used in this way to effectively limit liability.
Could I just ask you one more question on the facts? You showed us one of the paycheck services 9 limited printouts, and these are purport to be decisions in relation to particular payments to particular employees, do they, week by week?
Yes.
And so, for example, on page 253, the one we were looking at, it's a payment to Costin M, P2 a category shareholder on the register as at 12th of July, and the next one is the 19th of July. So you get
Correct.
one of these every week. So somebody presses the button every week
Yes. Hundreds and hundreds.
for every single employee of every single composite,
Exactly.
employee of a composite
Yes.
company.
This is the authorisation to pay that element of their remuneration, if I put it that way,
Yes.
that is being paid by way of dividend. Of course, they receive salaries as well, but you wouldn't need a board resolution in order to pay dividends.
Pay salary.
Well, some receive salary,
Yeah.
so they would receive that in the normal way, but because they're paying, because they're...
Because you wouldn't need a dividend, you wouldn't need a board resolution to pay the salary.
No.
They would need a dividend. Yeah.
Exactly so.
Thank you.
Because this is a company law act, you are distributing profits, even though it's organised in this way, as though it is effectively a salary check that they're receiving. Each company is every week declaring effectively interim dividends based on the available profits in the company. And my lords, it is important to bear in mind this whole structure, because they have deliberately set up a structure that requires the payment of dividends. And we've heard from my learned friend that the difficult position that they found themselves in on the 18th of August, but they were only in that difficult position because of the extraordinary setup that was here, requiring the payment of dividends. But there are strict company law rules in relation to dividends, and they have to follow them. One of those is having a board resolution authorising them to be paid. Well, although I'm conscious of the time, and I do need to come on to deal with some some of the other issues. Can I just say this finally in relation to corporate directors, that there isn't this retrospectivity that my learned friend sought to suggest based on wrongful behaviour. Therefore, the analogy with accessory liability claims are, in our submission, not correct. We're not seeking to make Mr. Holland a de facto director because of any wrongful acts that he's performed. He's a de facto director for other reasons, and it just so happens that he's then later in breach of his duty. The whole issue comes down to capacity and whether it is a general defence. And as I've submitted to your lordships on many times before, there is no distinction drawn between shadow directorship and de facto directorship in my learned friend's argument. And that leads to the rather extraordinary position that one had in Hydrodan, where Eagle Trust, of course, didn't have any lawful authority within the subsidiary company. There was no lawful authority to issue directions and instructions, but it issued directions and instructions authorised by its board. That is a third party. Of course, third parties must be liable under the shadow directorship doctrine. But if it's right that Hydrodan and the principles derived from it, as understood in the Court of Appeal, applies, this would mean that anybody, we give this example in paragraph 55 of our case, Mr. Holland could have entered into a consultancy agreement with the composite companies, not in his own name, but in the name of Michael Holland Limited. And so long as everything he did in relation to the composite companies was done in the name of Michael Holland Limited, he personally could not be liable. His capacity as a defence to both shadow directorship and de facto directorship, it is easy to set up a structure in which the individuals who are really controlling events manage to escape responsibility. Now, my lords, I must turn to the duty.
Yes.
The other issues. Can I first say that my learned friend suggests that there was a finding by the judge that these other claims, preferential claims and claims from creditors, would have arisen if they had stopped trading on the 18th of August, as your Lordship will recall. We do not accept that, and if your Lordships were to look at paragraph 268.2.4 of the trial judge's judgment, we would submit that that is not a finding that those other claims would have arisen.
268.2.4?
It's on page 127.
Yes.
And
Just lack of evidence as to what the effect would be, is it? I mean, just wasn't...
yes,
demonstrated.
he's saying about whether there would have been a balancing exercise that could have been sensibly done. In the middle of the paragraph, it says, difficult to say with any degree of certainty, except that additional unpaid HRCT arose, what the effect of continued trading was, and in particular whether, and if so to what extent, HMRC benefited from the fact that other contractual, and in particular preferential claims did not arise because of the seamless transition to the new corporate structure on administration.
But it's not ruled out absolutely, is it?
It's not ruled out absolutely.
I mean,
but it's
that's
not.
all Mr. Knox needs, because I think what he's saying, well, this would have to go back for assessment if he's right.
Yes.
I mean, maybe the answer
Yes.
is he doesn't get anywhere, but unless it's ruled out completely, the point seems to me in principle to be alive.
Yes. My Lords, as to the duty, my learned friend referred to there being the two lines of cases, strict liability or fault liability. And my Lord, those, and he didn't really deal with those. The relevant duty in this case that we say was breached is a general duty not to misapply company assets unlawfully and ultra vires. If it is ultra vires, it means it is beyond the powers of directors to do it. What is more is there is clear authority that such a breach cannot be ratified by shareholders. If it cannot be ratified by shareholders, it means in our submission that we're not, on proper analysis, talking about the equitable duty of care. We're talking about the duty of directors not to misapply the company's money. And although it's referred to in Learned Friend's case, extract from Gore Brown, I perhaps don't need to take your Lordships to it, but it's in volume 8, tab 90. There's a section there concerned with the director's trusteeship of company assets. And it is put in the form of almost a sort of sui generis type of duty, outside the statement of duties even set out in the Companies Act 2006. And we would submit that it is not sensible to talk in terms of breach of this simply being a breach of the duty of skill and care. No doubt it would be a breach in any normal case of the duty of skill and care. But the actual duty is a duty not to misapply the company's assets. And that is a trustee-like duty. And that is why we are in the territory of considering restoration of the dividends in full, rather than any compensatory type of relief. And, my Lords, I don't think it would be helpful, and certainly not given the time, for me to take your Lordships to any of those two lines of authorities. They were considered to a certain extent by Lord Justice Rymer, but he declined to rule on them. But the fact that there are those two lines of authority, and in neither of them is there discussion as to the duty of skill and care, indicates in our submission that we're not talking about that duty in this context. We're talking about a far more strict duty to comply with the Companies Act and not to misapply company assets. And it's a very serious thing. It's unlawful. And that is why the law imposes strict consequences in our submission. If they decide, as they did decide, to set up in this way, which involved the payment of dividends, they've got to get it right. If they don't get it right, they are liable to restore the full amount of the unlawful dividends.
This argument leads to
paid.
two conclusions, does it? One, that it isn't a reasonable care test. Is that right? And secondly, on the question of compensation, or however you describe it, the whole of the amount unlawfully paid has to be returned.
Yes.
Is that right? That's the
So
argument.
it does lead to that. It's because my learned friend is seeking to set up a case that this must be a case of a breach of duty of care. Therefore, one has the normal compensatory remedies that flow from that. We say no, it is a breach of trust type case. There still will ultimately be the issue of reasonableness because of Section 727. That brings in reasonableness. That's why at the end of the day, reasonableness will always be the touchstone of liability. But it comes in at that stage. It doesn't come in at the stage of the original duty. The original duty is strict, and that's why Section 727 is there, because the legislators realised, derived from the Trustee Act, that it can be harsh to impose remedies on a trustee or a director that has behaved perfectly honestly and reasonably, but is nevertheless in breach of trust. So Section 727, it all comes down to reasonableness, though the burden is on the director to prove that that is so. The original duty is therefore a strict duty, and in our submission, therefore, the target line is not applicable to this. We entirely respectfully adopt the way Lord Justice Reimer analysed the position, and it was a unanimous decision in our submission of the Court of Appeal that the appropriate remedy in an unlawful dividends case is restoration of those unlawful dividends in full. The argument from my learned friend is that in some way one can bring in the profits that were earned the following week and set it off against the unlawful dividends that were being paid the week before. In our submission, that rather demonstrates why, in an unlawful dividends type of case, one does not inquire into those sorts of matters. It is, one looks at the end of the day, we don't seek to stop the clock, one looks at the end of the day, what loss has been caused by the unlawful dividends being paid out. And that money is not available in the estate at the end of the day. £1.3 million has gone out unlawfully.
So in effect, you look at 263 subsection 1 and say what was the distribution that was made that should not have been made,
Exactly.
identify that amount and just give it back again.
Exactly so, my lord. And we would, my learned friend says, even on a traditional trust basis, as explained in Lord Millett's article, which I would invite your lordships to look at, perhaps not now, but what Lord Millett was suggesting was that the...
Have you got the reference?
Yes, of course. It's in volume 8. Tab 91.
91.
I'm grateful.
It is 91, yes.
The relevant passages are pages 225 to 227. What Lord Millett points out is that the actual breach in target was not the payment out of the money, it was the failure to get in the security for that money at the time the money was paid out. And once that is appreciated, and once one looks at the actual loss arising as a result of the failure to get in the security, which was nothing because the security was eventually taken in, there was no loss caused to the estate. In our case, the breach of duty is the payment out of the unlawful dividends. These weren't investments in any respect that could be said to produce a profit that ought to be brought back into the account. These were dividends that were paid out to shareholders. And if a trustee were to make an unauthorised investment which turns out to cause a loss to a trust, the trustee can't say that, well, if I hadn't made those unauthorised investments, the existing authorised investments that I should have had would have lost similar amounts, and therefore the breach of trust didn't cause any loss. All that can be brought into account is not hypothetical savings or profits. It is actual loss suffered at the end of the day. And in our submission, at the end of the day, in the liquidation, there is 1.3 million pounds worth of unlawful dividends that has been lost to the estate, to the company's estate. And those are the strict rules in relation to unlawful dividends. It is, I accept, a unique situation that we find ourselves in here. Probably won't happen again, but to a certain extent, anyone structuring their business in this way and relying on dividends should be aware of the consequences if they fail to get it right. In our submission, that is why the law is as it is. And can I finally say in relation to this that we certainly understood that the judgment in Bairstow, my Lord Walker's judgment, was not endorsing the use of target and compensatory principles to be brought into this area, and certainly that seems to have been the view of Lord Justice Rymer in the Court of Appeal in this case. And we submit that that is the appropriate approach for the law to take in this case. Can I turn to section 212? Because what my learned friend seeks to do is, if he fails on the loss point at that stage, he effectively seeks to bring it in again under section 212. We say that would be a rather absurd conclusion, given that section 212 is a purely procedural section. If under the general law, if say the revenue had funded the liquidator to bring proceedings, not under section 212, but to bring proceedings in the name of the companies against Mr. Holland, they would be entitled to the liquidators, effectively on behalf of the revenue, as the only real creditor in these companies, would be entitled to a return of all of those dividends.
But he does have the benefit of the words, as the court thinks just, in subsection 3b, doesn't he? That's not just procedure.
That is the point I'm making, is that even though section 212 is just a procedural section, if it is just a procedural section, as is accepted, then the discretion inherent in those words must be very limited indeed.
You deal with this very fully in your written case.
I'm sorry, my Lord?
You deal with this quite fully in your
Yes, I
written
do.
case.
I do, my Lord. I'm content for your lordships to look back at what we say in relation to that. But it would effectively amount, as Lord Justice Rymer said, to providing a further defence to liability. And in our submission, the discretion cannot be that wide. It is simply there in order to avoid this money going round in a circle situation. which would, of course, be unjust. It would be unjust for directors to have to pay money over to shareholders again. And, my Lords, can I finally just comment on my friend's suggestion that in some way this is the fault of the revenue, that they are in this position, and that should be taken account of in relation to this. My Lords, Lord Justice Reimer completely dismissed that point, and in our submission it is fairly absurd to suggest that the revenue can be blamed for Mr. Holland's payment of unlawful dividends.
Well, can we can just pick this point up from what he says by looking at it again, can we? You
Yes,
have a particular paragraphs in mind?
It's paragraph 112, Lord Justice Reimer's judgment.
Thank you.
My Lords, it's 3:30.
Yes. Well, we're extremely grateful to Council for all their assistance, both orally and in writing, and for adjusting the timetable, for which we're also grateful. We'll take time to consider our decision.